talk a little bit about arbitration. In employment cases, we see a number of our clients who have signed agreements with their employer that say they cannot go to court. Now, that does not mean that a client will not be able to have a hearing about their case. But what that does mean is that the client has signed what we call an arbitration agreement. So what's arbitration? Arbitration is an informal legal proceeding that has, instead of a judge, it has a private judge called an arbitrator who is appointed by both the plaintiff and the defendant, and they sit as the judge in the case. Now, arbitration has some advantages and some disadvantages. And most of the advantages to arbitration are in the speed of the process and that it's somewhat less formal. However, there are some significant disadvantages to arbitration because most of the time in arbitration, there is no right to appeal. And that means if the arbitrator rules in favor of the defendant, guess what? You lose, and there isn't very much that you can do about it. By the same token, on the flip side, if the defendant loses, they can't appeal that unless there's neither side can really appeal unless there are very specific grounds, and it's very difficult to appeal. The judgment that you get from an arbitration is just as enforceable as it would be if you'd gone to a regular court. The law is generally about the same as what you would see is if you went to a regular court. But the only main difference is the procedures that we will follow during the hearing and during the litigation. Usually it's a little bit more relaxed. Sometimes there's less time, so it goes quicker. And it's just a little bit less formal. We may not have to observe some of the rules that we would have to if we went to court. Now, a lot of employers seem to like arbitration. It does not mean that they will win, but it does mean that you don't get to have a jury to listen to your case. And the reason why employers like that is because they think sometimes the jury will side with the employee because they feel like the jury would be biased towards employees. Now, in my experience, that is not the case. Juries see things fairly, and they can see when people are being truthful or less truthful with them, and they are often the best people to determine what happens in a case. But if you have an arbitration, you will not be entitled to a jury, and that's the main difference that you will see in an arbitration case. So if your case is subject to an arbitration agreement, usually it will have occurred when you first applied for your job and were offered the position. When you go to orientation, there'll usually be a document that you signed during your orientation process. If you have not signed that document, then you cannot be compelled to go to arbitration unless you agree. And normally we would not agree. And so what will control whether you go to arbitration or you go to court is which documents you signed at the beginning of your employment, or sometimes an employer can come to you while you are actually employed and ask you to sign it later. They have every right to ask you to do that. There's nothing that you can do if that is a condition of your continued employment. But by and large, most people who sign arbitration agreements sign them at the very beginning of their employment, might not even notice that you had done it when you signed it because it was part of a big slew of documents that you signed at the beginning of your employment. But once you sign those documents, that means that you have given up your right to go to trial in front of a jury in a courthouse. Doesn't mean you won't win, doesn't mean you won't get justice, but it does mean that there'll be a slightly different process and procedure in place for you at that hearing.